So, why should Twitter, Facebook be called intermediary? When these social platforms are running our world today, aren't they more than intermediaries?
You're right from a perspective that these companies who are social media intermediaries or significant social media intermediaries, as they have now become, nudge the way society thinks, reacts, etc. Answer is yes. Do they have a great impact in the manner in which their discourse occurs in society? Answer is yes. Are they platforms by which world leaders today communicate? X has become a platform for world leaders to communicate with each other. There are no more cables, so to speak. Therefore, all of that is correct. But they are what they are, and they actually nudge the way the discourse occurs because they are given the status of an intermediary. And therefore, your question actually has the answer within it. I'll take an illustration. If you don't give them the status of an intermediary and burden these platforms to be responsible for the content that those platforms host, then these platforms will ensure that simply for survival, they will only permit clean content or a particular discourse in a particular manner and not permit quote-unquote unclean content. When I say clean and unclean, I don't mean legal and illegal content. I mean content from a particular perspective, which is the flavor of the day. Today, for example, in a country which is governed by a particular ideology, opposing ideology may be unclean content. And therefore, if the platform has that ideological discourse available, the government may clamp down on it, and therefore the platform is then forced not to permit a competing viewpoint on the platform. There is diversity of opinion. These platforms have become marketplaces for opinions to be traded. These platforms have become a wide gallery in which multiple discourses at various levels can occur because and only because these platforms are given the status of an intermediary, which means they are not responsible for the content on their platform. They do not decide what content will be on their platform. They do not decide who puts up that content on the platform. And lastly and most importantly, they don't decide who receives the content or information on the platform. Therefore, they don't choose the originator, they don't choose the recipient, and they don't choose the content. That gives them the status of an intermediary.
How safe are these intermediaries in India? And I ask it from the point of view that we often see government directly, on some occasions, in conflict with these intermediaries, especially when they seem to be hosting a certain kind of content. Here in India, what is this?
I'm a proud Indian, and I believe, therefore, from my perspective, you will always find a thought process which many people may agree, may not agree, but I think that's the right thought process, and we should be candid on that issue. I believe India is one of the fairer countries in the world, in fact, one of the better jurisdictions in the world, which has allowed a discourse and a mix of ideas to come on a platform. It allows dissemination of contrarian information. It allows for a debate. Therefore, let me answer the question in multiple counts. One, how safe are these intermediaries? According to me, these intermediary platforms are one of the safest platforms on which you can actually have a credible discourse occurring today. Why? The platforms themselves do not know what is the nature of the discourse. The platforms themselves granularly don't edit the discourse. The platforms do not granularly, of course, in any manner obstruct the discourse. And therefore, it is a free-flowing platform available for all ideas, plurality of ideas to come on the platform and a debate to occur. On safety, security, when have you seen that in a platform there is leakage of information or the platform has crumpled, etc.? In fact, hundreds of millions of dollars are spent by these platforms on an annual basis to maintain the integrity of these platforms. And more importantly, some of the larger platforms, take for example Google, take for example X, take some of the Meta platforms, they are all single platforms for the entire world. It's not that they hold country-specific platforms or they host country-specific content on a country-specific domain. They have a single domain for the world. They have a single platform for the world, and therefore the integrity and plurality of that platform is maintained. Thirdly, why do governments therefore attempt to, if I can use the word, clamp down on this platform? It's not really specific only to India. In fact, India is again one of the better jurisdictions. You look at a country like China, they have clamped down so heavily that some of the platforms of these larger intermediaries don't operate in that country. They've just moved out. That's not the case with India. Every international platform of any credibility is operating in India and operating well and operating successfully. They've become significant social media intermediaries because they have millions of users on a daily basis operating in India. Why do governments, of course, sometimes come hard at it? It's, I think, just a natural process. Today, if you look at criticism against the government in a democratic process, those criticisms at one point of time existed in print. The pen is mightier than the sword. The Indian Express days where critiquing the government was actually the agenda for a newspaper. Those things are gone. Which print media is actually taking on the government in terms of critiquing? When I say take on, I don't mean it in the negative way, but from a perspective of raising the right questions, asking the questions, trying to get the answers, and portraying it in an unbiased manner for the readers. Now that's happening on social media. Why? Because there is no single editor who is actually exercising editorial control over it. It is the users who actually have the plurality, and it is that plurality which brings that mix. And therefore, it is inevitable that governments in any jurisdiction, and US is not unknown to this, India, of course, has issues, notices left, right, and center on multiple social media intermediaries to take down a particular content. We have to actually bifurcate it in two buckets. One is content which is illegal. Second, content which some people find not savory to their ears. Content which is illegal, there is no two ways about it. After the Shreya Singhal mandate of the Honorable Supreme Court, and after what the Section 79 of the Information Technology Act says, a combined reading of 79 of the IT Act and Shreya Singhal, the law is very, very clear. If there is a notice from a governmental agency, or if there is notification of a court order regarding removal of a content on intermediary platform, the intermediary must necessarily comply with it. Because they are an intermediary. It is not for them to say that the content should or should not be available. It is not for them to say that they permit a particular view to be available on their platform. There is a direction for removal, you remove it. If you still believe that it should be available, it is amenable for challenge, but you need to remove it when you are notified. Now coming on to content which is not per se illegal, but content which a particular government of the day does not want to be available on a social platform. Now that's an issue of course, governments have their agenda in terms of governance. The social media users have their agenda in terms of plurality and debate. Therefore, notices come in. My experience with some of the large social media intermediaries is whenever there is a violation of their policies or whether there is violation of the law, they have always complied to take down content because that's the law. But whenever a government of the day or any other entity or any other instrumentality of the state is attempting to pull down content which the government believes is not palatable, the intermediaries have actually stood ground and said, none of the grounds made out under Section 79 or under Section 69 or under Article 19 thresholds of free speech, none of those grounds are made out and therefore we will not take down. The best illustration is, I think by one-line orders, the government of India had asked Twitter to pull down thousands and thousands of tweets and in some cases multiple handles, etc. Twitter, of course, because of the legal mandate complied, but then challenged it in court. The proceedings are on, the matter is pending in the Karnataka High Court. So I really think, therefore, from an India perspective, there may be cases where attempts are made to pull down content. If it is not legally viable, challenges are mounted, and that's the best part. In this country, you can challenge the action of a government, take it to court, and courts will give you due consideration. What more do you need in a democratic setup?
The last two aspects. One is the liability of it. On one hand, it is factually correct to say that they're not creating content, they're not choosing their users, they're not choosing their audience. But at the same time, when there is a clash, they do exercise some restraint and authority in saying, we're not going to take this down. There is a certain degree of editorial control that they do have. It's not like an open state where anybody can come and anybody can go just because the government is asking. In that case, to what extent intermediaries have been held liable in India? There is also a criticism that the liability that these intermediaries exhibit, say in a country like US and Europe or on the continent of Europe, is very different to their attitude here. Is that criticism that?
I'll answer the second question first. I think the criticism to say that social media intermediaries have a dual standard, they apply a different standard in the United States of America and they apply a different standard in India, at least in my experience, that statement is false. In fact, quite to the contrary, a social media intermediary applies the same standard that it applies in the US in India. The difference is the tolerance limits vis-a-vis community standards and governmental standards. I'll take an illustration. In the United States of America, burning the flag of the United States of America is free speech, it's expression. If I need to protest, I can burn the flag. I'm an American, proud American, but because of a particular governmental action in protest, I'm burning the flag. That is considered free speech and is permitted in the United States of America. If I burn the national flag here, would that be condoned in terms of law? It's an offense in this country to burn the national flag. The flag code does not permit you to do that. And I will have multiple criminal prosecutions against me. Now, what's different? Is the acceptability different or is the legal threshold different? Simply the community standards and legal thresholds seem to be different in these two different jurisdictions. Therefore, the kind of content that is asked to be pulled down in India is vastly different from the kind of content that is asked to be pulled down in a country like the US. Child pornography, etc. automatically taken down. Content which is violative of policies, that is hate speech and things like that, are asked to be taken down. They will be taken down in the US. Rarely in the US are content of some religious issues asked to be taken down. Jesus is portrayed in a bad manner. Nobody asks it to pull down. People laugh about it or people criticize it, but it is available. But you portray a Hindu god in a wrong manner, here you had it. It's a criminal offense again. Therefore, the nature of requests for content takedown is very, very different. And I'm not saying that the governments typically do it, but there have been instances in this country where governments have actually asked for content which is not palatable for the government to be pulled down. For example, let's take an example. Criticism of a tall leader here. Now, criticism about the Prime Minister here is far more seriously viewed at than criticism of the President in the United States of America. The kind of jokes and memes that go around Trump and Biden, if that same standard is applied for our political leaders here, the President of India and the Prime Minister of India, you had it. Therefore, an intermediary which pushes back in the US to say that, or which finds this to be acceptable that you can criticize the president and get away with it, the intermediary simply applies that threshold in India as well. And that is looked at as dual standard, saying, oh, in US you did not permit it, in India you permitted it. Actually, it is not. It is a uniform standard, not just for India and US. Some of these intermediaries operate in 190 countries in the world. They have a uniform standard, barring certain community guidelines. For example, information about the swastika and Hitler, etc. It may be taken down in Germany, but an image of a swastika may not be taken down in India, because it is perfectly acceptable that swastika is more a Hindu, religious, a prayer symbol, and not a symbol of actually the political wing which did what it did in Germany. So these community standards are different. Second, in terms of liability, I think the case is very clear. An intermediary must behave as an intermediary. An intermediary cannot stand up to turn up and say that I would like a particular level of discourse on my platform and therefore I support a particular view on my platform. It is not the intermediary's job to support any particular view or oppose any other view on its platform, because it must maintain that neutrality. Like you have net neutrality, you need to have platform neutrality. You let both discourses come on the table. Of course, you make sure that you have a particular policy statement so that the level of the discourse really does not dip so badly that it becomes offensive. For example, as Sandra Day O'Connor US said, you maintain the level of the discourse at the level of a mailbox and you don't bring it down to the level of a sandbox. So therefore, those are community standards which will be applied. Despite the community standards, let us say hypothetically in an illustration, there is content which is violative of your own community standards. There is content which is violative of the intermediaries' platform's policy itself. And there is content which is violative of the local jurisdictional law. And the platform has been notified, despite which the platform does not take it down. Of course, in such cases, platforms will expose themselves to liability. There have been cases where the platforms have been criminally prosecuted in this country. There have been cases in which the platforms have been actually hauled to court in terms of why ABC not been done. For example, on contempt of court issues, there are multiple high courts which have taken so much cognizance on contemptuous act by third parties on platforms and asked platforms to take it down. If they don't take it down despite a court order, they'll obviously face liability under the Contempt of Court Act. So there have been instances, but to generalize it to say platforms apply dual standards, in my experience, I'm a free speech lawyer. I've been representing intermediaries in this country for the last 12, 13 years rigorously. Even prior to this whole ecosystem of social media intermediaries becoming what they are, we have been from 2002-3 onwards representing the internet companies as they were then on free speech issues. I don't think that platforms sometimes, of course, can look to be stubborn or seem stubborn, but they don't have a duality in terms of their attitude. They have a consistent attitude. If they're stubborn everywhere. That's their platform. and you take it, leave it. You want to prosecute them, prosecute it, make out a case in law. But rarely have I come across a scenario that platforms apply dual standards in different jurisdictions. Certainly not between US and India. In fact, these platforms recognize India as a very mature jurisdiction. They will do well not to actually have dual standards.
Thank you so much for it.
Thank you.